Good morning, banking industry participants. This morning I just wanted to briefly mention the General Protection section of the Fair Work Act. What the section provides for is that if the employee makes a complaint or has a workplace right, the employer takes some action against them, so taking them off overtime, taking shifts off them, will lead to a potential penalty being available by a court. Recently, Qantas was subject to a full federal court appeal concerning an issue they had with one of their engineers. The engineer made two complaints to the federal court. The first was that he was employed out of Brisbane and did some work at Narita Airport in Japan. He was meant to get a higher rate of pay. When he came back after 6 weeks and complained, he was yelled at and abused by his boss, and secondly, he did not have his complaint dealt with appropriately in order for him to claim more money. After that period of time, he also claimed that he was denied the opportunity of promotion. The full federal court held that the yelling that the boss did at the employee was intimidation, and that was adverse action. Secondly, the denial of the employee claiming his rights and the heated conversation meant that the employer had taken adverse action to try and stop the employee making a legitimate complaint. So the lessons for employers are that if an employee is complaining about their wages, occupational health and safety, or some other issue, and the employer then decides to take adverse action against the employee, then you could be in breach of the Fair Work Act and face federal magistrate court or federal court proceedings. Secondly, the onus of proof in these cases is that the employer must prove that they took adverse action for reasons other than the employee claimed. All the employee has to do is prove that the actions taken happened, and then the onus switches to the employer to prove that they took action for reasons other than those claimed by the employee. So, for example, if the employee is terminated for poor performance, but they made a complaint, then the employer must prove that the employee was terminated for those performance-related reasons. Secondly, the fines are very, very high, up to $33,000 for a corporation. So it's very well worth staying away from this particular section of the Act.